Hello friends, I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. Dear friends, the topic of our today's talk is separation of powers and independence of judiciary. Dear learners, the present module will make you acquainted with the doctrine of separation of power, idea of French philosopher Montesquieu on separation of power in ancient India, importance and need of the doctrine of separation of powers, doctrine of separation of powers and constitutional perspective, three organs of the democratic government, the concept of independence of judiciary and constitutional perspective of the independence of the judiciary. So friends, let's start with brief introduction of the topic. The French political philosopher Montesquieu is credited with developing the idea of separation of powers, which emphasizes the mutual exclusivity of the legislative, executive and judicial parts of the government. This philosophy is based on the idea that each branch of government should only be responsible for a single type of task to prevent the concentration of power in one branch. Such a concentration of power can allow any one organ the freedom to act arbitrarily and adopt oppressive legislation without any checks or balances. Consequently, this doctrine's objective is to hinder the use of arbitrary power rather than to boost administrative effectiveness. Every state has three fundamental institutions: the legislative, the executive branch and the judiciary. To prevent arbitrariness or dictatorship, there should be a distinct division of responsibilities between these three institutions. According to the theory of separation of powers, most of the time the idea of an independent judiciary is associated with the concept of separation of powers. The theory of separation of powers mandates judicial independence. In India, a separation of functions rather than powers is followed. Unlike in the US, in India, the concept of separation of powers is not adhered to strictly. However, a system of checks and balances has been put in place in such a manner that the judiciary has power to strike down any unconstitutional laws passed by the legislature. The American Constitution in its articles 1st, 2nd and 3rd recognizes the theory of separation of powers, allocating legislative, executive and judicial authority among different branches. In India, there is no rigid separation of powers like American Constitution, and this doctrine also has not been accorded a constitutional status. Apart from conferring executive power with the President and Governor and a directive principle under Article 50 of the Constitution of India, which urges separation of judiciary from the executive, the Constitution of India does not contain any formalistic separation of powers. However, despite this, the Apex Court of India in the case of Keshwananda Bharti versus State of Kerala held that doctrine of separation of powers is enshrined in the Constitution's basic structure, and none of the Republic's three separate organs can assume the functions of the other. Further, the Apex Court of India in the case of State of Tamil Nadu versus State of Kerala also held that although the doctrine of separation of powers is not expressly enshrined in the Constitution, its scope, operation and visibility are evident from the Indian Constitution's framework. While explaining the separation of powers, the court in the case also held that one of the key pillars of the rule of law and the Indian Constitution is the independence of the judiciary from the government and legislative. Moving further, dear friends, it is very important to understand the meaning of doctrine of separation of power. The separation of powers is immutable for the administration of federative and democratic states. Under this rule, the state is divided into three different branches: legislative, executive and judiciary, each having different independent powers and responsibilities so that one branch may not interfere with the working of other two branches. It is the rule that every state government should follow to enact, implement the law and apply it to a specific cases appropriately. If this principle is not followed, then there will be more chances of misuse of power and corruption. If this doctrine is followed, then there will be a less chance of enacting a tyrannical law, as they will know that it will be checked by another branch. It aims at the strict demarcation of power and tries to bring exclusiveness to the functioning of each organ. The doctrine of separation of power is known to us by Montesquieu, as he gave an absolute status and difference between the functions and powers of the executive, the legislature and the judiciary. Aristotle was the first one who wrote about it, but not in an obvious manner. In his book, analysis has been found of three parts, or we can say branches: the deliberative, executive and judicial, and has explained it as all constitutions have three elements concerning which the good lawgiver has to regard what is expedient for each constitution. When they are well ordered, the constitution is well ordered, and they differ from one another. Constitutions differ. There is one element which deliberates about public affairs. Second, that concerned with the magistrates. The question is what they should be, over what they should exercise authority, and what should be the model of electing to them. And thirdly, that which has judicial power. But Aristotle does not stress it in a specifying way. Friends, now I would like to put light upon Montesquieu's opinion on separation of power. The French philosopher Montesquieu believed that power should be a check on power, because it allows the executive, legislature and judicial branches of the government to work as a check on each other. Power halts power. According to his views, when the legislative and executive powers are united in the same person or same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in tyrannical manner. Again, if the judicial branch is not kept apart from the legislative and executive branches, then there is no liberty. The subject's life and liberty would be subject to arbitrary control in cases where it merged with the legislative branch, because the judges would then be a legislator. In cases where it intersects with the executive branch, the judge may act oppressively and violently. Everything would come to an end when the same person or entity, whether made up of nobles or commoners, would exercise the three main powers: enforcing the law, carrying out popular decisions and advancing particular causes. The division of powers based on function is known as Montesquieu's submission, and the philosophy that emerged from it is called the separation of powers. One of the main tenets of the political theory of the 18th century was the contemporary idea of the division of powers. Moving further, now we will discuss separation of power in ancient India. It should be noted that although Locke and Montesquieu are credited with discovering the separation of powers, the Vedas are the source of this concept. Such a division can be found in the Smritis, an ancient source of law or dharma. We may trace the fundamental idea of power division back to the Nard Smriti. At the time, Senapati was in charge of the upholding law and order, Qazi headed the judiciary, and Diwan led the executive branch of any legacy. However, we must remember that they are all under the king, who was the ultimate power and enacted laws, making him comparable to the current form of government. In summary, the findings indicate that a division of authority within a province or legacy existed historically as well. After all, king is known as the supreme authority of all, but the functions and powers have been separated. Further, meaning of separation of powers. The theory of separation of powers signifies three formulation of categorization of government powers. The same person should not form part of more than one of the three organs, that is executive, legislature and judiciary. For examples, judges should not sit in parliament. One organ of the government should not interfere with any other organ of the government. One organ of the government should not exercise the functions assigned to any other organ. The next one is importance and need of the doctrine of separation of powers. The concentration of power in one center authority can lead to maladministration, corruption, nepotism and abuse of power. Separation of powers help in to prevent autocracy, to create efficient administration, to maintain independence of power and to prevent the legislature from enacting arbitrary or unconstitutional laws. Further, dear learners, it is pertinent to understand the doctrine of separation of powers and constitutional perspective. In India, there are three major powers of the government and each of them is performed by a separate organ. The legislature is responsible for making the laws, executive is responsible for enforcing the law, and the judiciary is responsible for protecting laws. The major question that arises is whether should there be dependence of these organs on each other or whether there should be a strict separation of powers among them. There is a strict provision that defines the separation of powers absolutely, but there are provisions in the Constitution of India that have made distinction between the powers of the organs of the government. Even though there is no express provision for this doctrine, it is impliedly followed in India. It has defined the roles of each organ of the government. The Constitution of India had laid separate function for the organs of the government in the following ways. The judiciary is independent as laid down under Article 50 of the Constitution of India. The conduct of the judges cannot be taken about in the parliament and state legislature as provided under Article 121 and 211 of the Constitution. The powers of the executive are vested with president and in a state are vested with the governor as per Article 53 and 154 of the Constitution of India. The legislature in certain cases like the impeachment of the president or removal of the judges of the Supreme Court and High Courts may have judicial powers. Likewise, executive has certain powers to appoint the judges and chief justice which can affect the functioning of the judiciary. The executive can exercise the powers of the legislature in circumstances when legislature is not in session and there is an urgent need to make law. This is provided under Article 123 of the Constitution of India to promulgate ordinances. The Constitution has also provided a system where checks and balances are done to prevent misuse of powers that have been vested. This clearly shows that Constitution of India does not provide a rigid structure for this doctrine of separation of power. It is used in a broad sense and the three organs can exercise their powers and functions even with some overlap. Further, three organs of the democratic government. The first one is legislature. The legislature is a law-making body. It has the authority to make laws for a political entity such as country. A law enacted by a legislature is normally known as primary legislation. The legislature forms the base for the functioning of the other two organs. Second organ is executive. The executive is the administrative head of the government which includes prime, chief minister and president, governors. The executive is completely dependent on the powers the legislature grants it. And the action of the executive may or may not be subject to judicial review. And the third pillar is judiciary. The judiciary is the watchdog of democracy. as it guards the Constitution. The judiciary comprises the Supreme Court, High Courts, District and other subordinate courts. Dear friends, the next part of this module is the independence of judiciary. An independent judiciary is the sine qua non of a vibrant democratic system. Only an impartial and independent judiciary can stand as a bulwark for the protection of the rights of individuals and mete out even-handed justice without fear or favor. The judiciary is the protector of the Constitution, and as such, it may have to strike down executive, administrative and legislative acts of the center and the states. For the rule of law to prevail, judicial independence is of prime necessity. The independence of the judiciary is normally assured through the Constitution, but it may also be assured through legislations, conventions and other suitable norms and practices. The Constitution or the foundation laws on the judiciary, however, only the starting point in the process of securing judicial independence. Ultimately, the independence of the judiciary depends on the totality of favorable environment created and backed by all state organs, including the judiciary and the public opinion. The independence of judiciary also needs to be constantly guarded against unexpected events and the changing social, political and economic conditions. It is too fragile to be left unguarded. In India, the question of independence of the judiciary has been a subject of heated national debate over the last many years. It has exercised the minds of legislators, jurists, politicians and laymen. Both the supporters and the opponents have cogent argument in support of their views. This question assumes great importance whenever the Supreme Court holds a particular act or particular clause of an act passed by Parliament ultra vires of the Constitution. Dear friends, further we will discuss what does mean by independence of judiciary. Simply stated, independence of judiciary means that the other organs of the government, the executive and legislature, must not restrain the functioning of the judiciary in such a way that it is unable to do justice. The other organs of the government should not interfere with the decisions of the judiciary. Judges must be able to perform their functions without fear or favor. Further, we will discuss constitutional perspective of the independence of the judiciary. Though in India there is no express provision in the Constitution, the independence of judiciary is imbibed in the letters of various provisions of the Constitution. Independence of judiciary and rule of law are the basic features of the Constitution and cannot be abrogated even by constitutional amendments, as observed by the Honorable Supreme Court in case of S.P. Gupta versus Union of India. The judiciary has a single pyramidal structure with the lower or subordinate courts at the bottom, high courts in the middle and the Supreme Court at top. For funding and some administrative purposes, subordinate courts are subject to regulation by the respective states, but they are basically under the supervision of the high courts. The high courts are basically under the regulative powers of the union, subject to some involvement of the states in the appointment of judges and other staff and the finances. The Supreme Court is exclusively under the regulatory powers of the union. Subject to territorial limitations, all courts are competent to entertain and decide disputes both under union and state laws. The unitary character of the judiciary is not an accident but rather a conscious and deliberate act of the Constitution, makers for whom a single integrated judiciary and uniformity of law were essential for the maintenance of the unity of the country and uniform standards of judicial behavior and independence. The members of the Constituent Assembly were very much concerned with the question of the independence of the judiciary and accordingly made several provisions to ensure this end. The Supreme Court of India has emphasized the independence of the judiciary from time to time and has observed that the constitutional scheme aims at securing an independent judiciary, which is the bulwark of the democracy. The Constitution of India adopts diverse devices to ensure the independence of the judiciary in keeping with both the doctrines of constitutional and parliamentary sovereignty. Elaborated provisions are in place to ensure the independent position of the judges of the Supreme Court and High Courts. Firstly, the judges of the Supreme Court and High Courts have to take an oath before entering that they will faithfully perform their duties without fear, favor, affection or ill will and defend the Constitution of India and the laws. Recognition of the doctrine of constitutional sovereignty is implicit in this oath. Secondly, the process of appointment of judges also ensures the independence of the judiciary in India. The judges of the Supreme Court and High Courts are appointed by the President. The Constitution of India has made it obligatory for the President to make the appointments in consultation with the highest judicial authorities. He, of course, takes the advice of the Cabinet. The Constitution also prescribes necessary qualification for such appointments. The Constitution tries to make the appointments unbiased by political considerations. And thirdly, the Constitution provides for security of tenure of judges. The judges of Supreme Court and High Court serve during good behavior and not during the pleasure of the President, as is case with other high government officials. They cannot be arbitrarily removed by the President. They may be removed from office only through impeachment. A judge can be removed on the grounds of proven misbehavior or incapacity on a report by both houses of Parliament supported by a special majority. Fourthly, the salaries and allowances of judges are charged to the Consolidated Fund of India. Further, salaries and allowances of judges of Supreme Court and High Courts cannot be reduced during their tenure except during a financial emergency under Article 360 of the Constitution. Fifthly, the activities of the judges cannot be discussed by the executive or legislature except in cases of their removal. Sixth, the retirement age is 65 years for Supreme Court judges and 62 years for the High Court judges. Such long tenure enables the judges to function impartially and independently. With this, I would like to conclude the module by saying that the doctrine of separation of power and independence of the judiciary must be judged not only in an absolute way but about its actual purpose. The only way to fully extract its meaning is to have a broader view and perceive it within a wide context, especially in this age of privatization, anarchy and globalization. Limiting it to just the idea of being used as a medium of categorizing that rigorously should not be done. Instead, should be used in good spirit of unity, collective enhancement and for the greater good of the people. It can be argued that this idea or notion is not compatible with work in its literal meaning, but it can do so and succeeded by emphasizing the checks and balances that are placed to make it good government in its true form and make it possible to eradicate power, manipulation and misuse by different sections and domain of the government. So friends, with this we will end today's talk. See you in the next module. Thank you very much.